ma'am, to welcome the gathering and speak a few words about today's session. Over to you, ma'am.
Saira. Saira, ma'am is engaged in another program, principal
Oh,
program. So you can directly ask Niveda to deliver welcome address.
yes, ma'am. I now invite Niveta of second year MBA to give a brief introduction about the guest of the day. Over to Niveta.
Good morning, all. Mr. Balaji Periyasamy LLM is an advocate practicing before the Delhi High Court and intellectual property offices across the country. After completing postgraduate in Law of Indian Law Institute, New Delhi, with specialization in intellectual property rights and corporate laws. He has over 9 years of experience in the field of laws related to intellectual property rights, having worked with a leading IP management company and a top tier law firm in New Delhi NCR. He is an active member of Manunidhi Legal Awareness Organization, registered under the Societies Registration Act 1960, and has been involved in organizing and conducting legal awareness program at schools and college levels. Once again, I welcome you, sir. Over to you, Saira.
I request you to continue the session, sir.
Sir, not audible. No, sir. Sir, no voice. No, sir.
Dear students, there was some technical issues, so this joins shortly. Sir will join shortly.
Yeah, is it audible now? Oh, sorry for the
Yes, sir.
slight
Yes, sir.
glitch. Actually, there's some problem with my now it's working fine.
வாய்ஸ் கேட்க மாட்டேங்குது. சவுண்ட கேட்கல சார்.
Sir, it is not audible, sir. So we couldn't hear, sir. Hear you, sir.
Yeah. Now is it audible?
Yes, sir.
Now it's working fine, right? One Meenakshi ma'am, is it audible now? Is it working fine?
Yes, sir. Everything fine. You can start, sir.
Sorry, actually,
It's
there
okay.
have
It's
been so
okay.
many.
It all happens, sir. Everywhere. Now we can start, sir.
Yeah, fine. To introduce myself, like Nivedita was introduced, I am Advocate Balaji. I am practicing before Delhi High Court, and I am also practicing before different intellectual property offices around the country. And my main focus is intellectual properties with specialization on patents and trademark matters. I've been practicing law for the last 9 years, and I've been working with different law firms across the country. I have worked with a law firm in Delhi and also helping other law firms in getting their claims, trademarks, and patents registered and dealing with their law litigation matters. And it's really happy to give you a session regarding intellectual property rights because as a part of one private NGO, I've been giving legal awareness sessions for different schools and colleges, but I have never given an intellectual property related session. And this is the first session, and I'm really happy to give this session as IP is my main field of interest with respect to law. And I just want to understand how much you are aware about the intellectual property rights. Just want to know if anyone can tell me if you have any information or awareness about the IP right, different forms of IPs and all, so that we can continue our session with taking the basic information from there. So, is anyone ready to give their idea about intellectual property rights, the reason for intellectual property rights, benefits and protection kind of things?
Sir, it's new to them. They are going to
Okay.
learn from you only, sir. After the
Okay.
session, they will ask some questions, sir.
Okay, fine. In that case, I will just give you some brief information about intellectual property rights, why these rights have been granted by the government, what are the benefits of these rights, what are the different forms, and how these are applicable to your day-to-day life and all. So, and then you can ask me questions about it. To start with, from the word itself, the word intellectual property itself is very descriptive. We can understand intellectual is something which is related to your thinking, invention, intellectual thing, which is related to your mind and thought process. So intellectual is something related to the thought process, and property which someone can own, right? So, like a normal physical property, which is like your house, your car, your phone, your pen, these are physical properties. So, same like that, intellectual property is something associated with your mindset, with your thought process, with your thinking capacity, imagination, invention, and all. So, same like normal physical properties, which are protected by the government, which are protected by different laws of the land. For example, if you own a car, you are the owner of that car. You have RC registration certificate for that car in your name, and you can use that car as much as you want, and you can also sell it. You can let it for rent and everything. You can use that car which you have purchased. Same like that. You have a property in your name. You can use your property. You can sell it. In the same way, there is a need for protecting the rights which are the property which is coming out of your mind in intellectual thinking. So to protect that kind of new innovation which is coming from your mind, which has no physical form, this kind of protection mechanism has been introduced internationally, so that some kind of rewards and recognition will be given to you in respect of your intellectual property rights. So same like physical property, intellectual properties are also having different options. Like apart from using your intellectual property for your own purposes or manufacturing and selling it for public, you also have the right to enforce it against others. So if you have an intellectual property rights, you can stop others from using that intellectual property rights, because physical property is like something which nobody can copy. If you have a house, nobody can copy the same house like that, and that you cannot protect in that way. If you have something in your intellectual capacity, in your intellectual thinking and thought process, if you have innovated something, that kind of properties needs some kind of protection against misuse by others. That's the main reason why intellectual property rights are recognized internationally, including in India. And these intellectual property rights are protected in different forms with respect to the nature of the rights as such. So these intellectual property rights are basically coming from your individual's mind process, thinking process, and innovative skills. There are actually different types of intellectual properties. There are at least 6 to 7 types of intellectual properties. These intellectual properties are playing a major role in everyone's day-to-day life. Like, for example, if you take a pen, that pen has different features, different designs, different brand names. These are actually protected as intellectual property rights only. In a pen, if there is a particular technology which is used for simple when you're writing, the fluid flow and everything is a technology. That technologies are protected as a patents. This is the main intellectual property type. Patent is the first and foremost type of intellectual property rights which can be protected. And the second one is trademarks. Take the same example, a pen. In the pen, it has the brand name, be it a Parker or Lexi, whatever, Raylands, whatever it is. That pen has a brand name. The brand name is protected as a trademarks. And each pen has a different design, right? One normal ballpoint pen have a different design. A Parker pen has a different design. So these designs are protected as the industrial design rights. So when you're using a pen to write a story, then the story you can get a copyright for that story. So in our day-to-day life, everything has been protected under intellectual property rights. Whatever you're using, whatever you're seeing, everything is having some kind of intellectual property rights in it. Same like the take for example your mobile phone. Your mobile phone has so many patent rights in it. Like for example, if your mobile phone has a 4G or 5G technology, then that's also a patented technology, which has been patented by different entities internationally. Same like that in your mobile phone, if you are using if you are seeing some, if you are using any app which has an icon, that icon itself is a logo of a particular brand, which is protected as a trademark. Same like that, the different softwares and the code, source code used in that particular app, it has some code. That codes are protected under Copyrights Act, because these are kind of literary and computer software related works which can be protected under Copyrights Act. And like I said, for a pen there's a design. For each mobiles there's a design. These external appearances are also protected as intellectual property rights. So each and everything we see and use in our life, it has some kind of intellectual property rights which are protected, and which are protected in the name of some individual or a company internationally. And whenever you are using that technology, we are indirectly paying to that particular company and individual who owns property rights in that one. By way of, when you're buying a mobile phone for, say, for example, for 15,000 rupees, this 15,000 is not just for the manufacturing company, because that company, for example, if you are purchasing a Samsung mobile phone for 15,000 rupees, this 15,000 rupees is not just for Samsung. Actually, Samsung is having some license agreement with some other companies who owns intellectual property rights in the technologies, like for 4G, for chips, for memory and everything. Different companies are having some intellectual property rights in it. And Samsung, when they're using that intellectual property in their mobile phone, they are indirectly paying it to the company, and they are collecting it from your, I mean, the purchasing price only. So like I said, out of different types of intellectual property rights, there are only four major types, like patents, trademarks, copyrights, and designs. In addition to that, there are other types of intellectual property rights, geographical indications, like plant varieties, trade secrets, and all. These geographical indications, plant varieties, and farmers' protection rights. These are not which are not used in our day-to-day life, but these are also protected as intellectual property rights. For example, geographical indications, it means some kind of product which is coming from a particular geographical location and it has some quality attached to it. Take for example, in Tamil Nadu itself, we have our Kanjipuram Pattu. So this weaving, silk weaving is the Kanjipuram city and the towns and villages around that locality has some kind of technology and expertise in weaving silks. And these silks are protected as geographical indications internationally. In India, it's already registered as a geographical indication. So the people who are attempting to misuse that geographical indication, they can be excluded by those who are actually producing that product from Kanjipuram. So geographical indications are like giving some kind of quality to the product on the basis of the place where it is being manufactured. So same like the Kanjipuram Pattu, we have this Salem mangoes, like even Basmati rice. There's a dispute going on with respect to Basmati rice between India and Pakistan. Basmati rice is being produced in the Sindh Valley. It's both in India and Pakistan. When it comes to production at the international level, India is India is trying to register it as a particular geographical indication of our country. At the same time, Pakistan is also claiming rights for the same. So geographical indication is not something which is related to an invention or something. It's actually a product. It's actually a location where that particular product is specialized and it has some brand value attached to that particular location. Same like that, apart from geographical indication, there is some intellectual property rights called plant varieties and farmers' productions rights, trade secrets, semiconductor industrial integrated circuits rights, and all. These are not very major, so we will just, since this is an introductory session, we will just focus on four major types of intellectual property rights, like patents, trademarks, copyrights, and design. To begin with, this patent rights is something which everyone will be hearing in this times, in this COVID times. Everyone, you must have heard about the patent waivers with respect to the COVID vaccines and COVID medicines and all. Patent rights is something, it's a kind of protection given by the government to an inventor or a creator of a particular technology or product. This technology and product, which must be a new thing, which is not known to the public earlier, and it has some industrial applicability, it has some benefit and enhanced use. For example, if there is a mobile phone which is having some technology like 3G, and someone is creating a 4G technology which is something new, because 3G has some kind of speed restriction. And when someone is coming up with an invention which is related to a 4G technology with additional speed, which is much more higher than the earlier technology available in the market, and which is new and which can be used by public, that can be protected as a patent right. This patent is not just limited to a particular field like a mobile phone or engineering technology. It's actually a broad field. It covers different things like pharmaceutical industry, mechanical industry, for airlines. Airlines are using some different machines, enhancing their engines and all, and getting patents for that one. All these technologies, the advancement to an existing technology which is not known to the public earlier, these new inventions can be protected as a patent. So this patent is a kind of protection given by the government for a new invention to actually, this is granted. What is the reason for granting patent? It is actually nothing but giving that inventor some credit, some kind of reward to that inventor. Because if there is no kind of protection given to that intellectual thinking and intellectual innovation which has been skilled by that particular inventor, the inventor must have spent so much money in that field to prepare that particular product. But if there is no protection available to that product, then everyone will be free to copy that product and everyone will be launching their own product under using the same technology. So to avoid that, to give some credit to the inventor, the patent right has been granted by the government for a limited period of time only. Patent is not like a endless thing which can be enforced by the inventor against others. Patent is actually a limited period protection granted by the government. The period is actually 20 years. In India, it's 20 years. In few other countries, they are giving protection for more than 20 years, but that is also limited. That is not like a particular inventor can get protection for a endless period of time, X period of time. It's only a limited period, a limited protection, which can be used by the particular inventor to monetize it, to use it, to sell it to others. The particular person who has been granted patent can use that himself to manufacture the product and sell it in the market. Same time, he can give license to some large companies in case if the particular inventor is a new, is just a individual. He has created some new technology. He can even license it to some third parties like big companies to use that particular invention in respect of their products, and he can claim royalty from them. He can generate revenue on the basis of that license that has been granted to that particular company. So this is the benefits of granting patent. When a particular person is getting a patent granted in his name, it adds some value to his portfolio. Actually, it's kind of an inventor. He will be recognized as an inventor of the particular patented product. Then he can use the product to as much as extent he want to, like for like I said, for selling that particular product, or for you giving license, or entirely transferring it and all for a particular period of time. So for patent, the main common misconception which is existing among public is that when someone is inventing a new technology, new invention, if there is a new invention, what happens is they generally go and disclose it to the public, or they generally publish it in a news article or a particular journal or anything like that, to say that they have invented something. But the problem with Patents Act internationally is that if you have some invention and you want to protect that invention as your own, you don't have to disclose it unless you file a patent application for that. Because what happens is, if you have already published that information in a research journal or article, that invention will be considered as in a public domain, because you don't have rights, registered rights in respect of that particular invention. Registered patent right is not in respect of the particular invention. Then if it is available in the public domain, anybody can claim ownership, anybody can claim, or anybody can use that invention without giving any credit to you. That is a problem. So what needs to be done is, when someone invents a particular technology or a particular product which is new, which is not available in the market, they have to first focus on getting it registered in his name. That's a very important thing with respect to patents. Only if you get it registered in your name, then only you can protect it, then only you can use it and generate revenue out of that particular invention. If you are just disclosing that information, then anyone can use it because it's in public domain. At the time of filing your patent application, the patent office, what they do is they will examine that invention. They will examine it and they will compare it with the previous invention available in the market. They will do a public search. They have a complete database of different inventions. So if your invention is already published in a particular news journal or somewhere, then the patent office will not grant you protection because it's already available in the market. The information about the particular technology and invention is already available to public. When the information is available to public, nobody can claim protection over that. So the main thing with respect to patent is, whenever a particular inventor finds finds an invention to be new and which can be registered as a patent, they have to go for filing it as a patent application. After filing the patent application, then you can disclose it to anyone. Because once you file it at the patent office, you will get a filing number. Your invention will be recorded as a patent application in your name. Then you can go and disclose that information. You can market it. Immediately after filing patent application, there will be so many companies which will be interested in purchasing the product from you. So only when you have a patent application with a filing date and filing number, then only you will be able to claim rights over that particular technology. Because when you are publishing it in a journal or a news article, your name will be there, but you cannot claim rights because you cannot claim protection in respect of the invention because it's already made available to the public by way of news articles or journals. So with respect to patents, the main thing is that once there is an invention which a particular inventor finds it to be a new thing which is not available in the market earlier, and which will be of some use in addition to the different functionalities available in the existing knowledge in the technology, then that needs to be protected as a patent rights. And for protecting it as a patent right, you will have to go and file a patent application first. Then only you will have to disclose that information to general public. What happens? Some companies, after having a research team, they have a separate team for prosecuting the patent application. Whenever there is an invention, what they do is they go and file a patent application first, and then only they will disclose that information to their dealers and all, so that they will be able to purchase the product. But the first thing which they do is file a patent application, irrespective of whether the patent application will be granted or not by the intellectual property office. They file it first to claim priority over that particular invention. So when you file a patent application at the patent office, like I said, the patent office will examine your application if to see that if that invention is new or it is different from the existing invention, and all, they will examine this in comparison with the prior filed patent application and prior information available in the public domain, and then they will issue an examination report whether or not to accept that application for registration. So once the patent office accepts that application for patent application, registration of a patent, then they will give you a certificate of registration of patents in your name. Once you get the patent registration certificate, it will be valid for a period of 20 years. So within that 20 years, what we can do is the inventor, the owner of the particular patented invention, they can as much as exploit that information. They can only sell that information, their patented technology. They can exclude others from copying. They can exclude others from manufacturing some goods on the basis of this technology. They can stop, and they can also claim damages from the other person, the party who is misusing the trademark. For example, if you have some kind of inverter technology, like already there are some inverters which are operating on batteries and solar thing. So if you are inventing some inverter technology which is from a new product, like from or something, you can register that product, and once you have a patent granted for the technology, you can only use that invention. You can only manufacture and sell that information. You can only grant license to others. Nobody can manufacture a particular product on the basis of your patented technology without getting rights and license from you. So if anyone is using that information, anyone is using that invention without obtaining your license or approval, you can file a lawsuit against that person, and you can claim whatever the profit he has made using that invention. You can also get that profit, accounts of profit and damages from the courts. Courts will grant you damages on the basis of your patented information. So when you have a patented product in your hand, you have a rights for 20 years to exclude all others from using the same technology. So apart from using it, there is also a plus point in getting your patent registered. Whenever you have some patent registered in your name, the patent office actually publishes the information in their journal, which is available internationally. So if some company which is trying to manufacture a product using a new technology, which is something which you have invented, then they will approach you to get that patented technology used by them. So it's not just a national thing. Once you get your patent registered in India, there are so many international patent databases. Like in EU, they have EUIPO. They have a database of different patent offices around the world. So once your patent application is granted in India, different person from different countries will be able to see it. But the only glitch is that patent protection is territorial in nature. So when you register your patent in India, you will be able to enforce that rights only in India. If you want to protect that information, if you want to protect that patented technology outside India, you will have to file a separate patent application in those countries. But the plus point is that India is a party to some international treaties which are recognizing this intellectual property rights. Like India is a party to a trade-related aspects of intellectual property rights. India is a party to Paris Convention, which is related to intellectual property rights. So once you have an application filed in India, and if you find that this invention will be beneficial and if this invention will be useful if registered in other countries, you have some period of time like 12 months period to file your patent application in other countries. So once you have an invention and you are filing your invention in India as a patent application, so you will get 12 months time period to file the same application for the same invention in other countries as well without losing your priority. So within that period, if someone is trying to register that particular invention in other countries, you will get priority. The patent office in that country will refuse the other party's application, and you will get priority on the basis of this international conventions. So, if you want to protect your rights, if you want to protect your patent rights in country other than India, you will have to file your patent application in those countries separately. And there is another option to file international patent applications through a treaty called Patent Cooperation Treaty. This patent cooperation treaty is very much important in terms of protecting someone's intellectual property rights, particularly patents, in different countries at one go. What happens is once you file a patent application in India, you can file a patent application at this intellectual property office. It's called as WIPO, World Intellectual Property Organization. So you can file your international patent application through the patent cooperation treaty at the WIPO, which will be designated to different countries, which will be protected in different countries. So if you decided to enforce your rights, if you want to protect your rights in different countries across the globe, you can use this patent cooperation treaty. You can use this World Intellectual Property Organization to file your patent application in different countries at one go. Instead of filing it in different countries at different time, you can choose this option to file it at one go. And different nation has their local procedures which will follow subsequently. But you will be able to get your international patent registered at one go. So the inventor who is interested in getting the patent registered in India as well as internationally, they will have to choose these routes, but they have to get their rights, the invention registered in those countries to protect that rights, protect that particular invention in those countries. It is very much relevant that registration of a particular patent is uh, made in different countries so that that product can be used and sold and enforced in those countries. So this is all with patents. So to recap about patents, patent is just a kind of protection and rights granted by the government to a particular inventor in respect of his invention, which is not something which is already available in the market, which is new and which has some industrial applicability, which has some benefits in addition to the existing benefits. So if there is a new invention, it can be protected as a patent. And for protecting a patent, one has to file the application first before disclosing it. And in case if they want to protect that invention in multiple countries, they have to file it in different countries because patent is territorial in nature. Once you get a patent registered in India, it will be protected only in India. You will have to file your applications in different countries so that you can protect your rights in those countries as well. Okay. And the second major type of intellectual property is trademarks. Same like patents, trademarks is also intellectual property rights, which is some kind of thinking. Trademark, it includes various things like if a company is starting their business under a particular corporate name, that brand corporate name is also protected as a trademark. At the same time, if the company is having multiple products under the corporate name, those multiple products, name of those multiple products are also protected as a trademark. For example, if Tata is into motors, Tata is the corporate name. It's a housemark kind of thing. Tata and the logo that Tata is using, it's a housemark, which is also protected as a trademark. At the same time, different brands, different car variants which are launched by Tata under that brand housemark Tata is also protected. For example, Tata has different cars: Tata Safari, Tata Sumo, Tata Indica, Tata Nexon. There are different brands they are launching. So all these sub brands, these are the product names. These are also protected as trademarks. Trademarks is basically it means something which can associate a particular product to a business of a particular person. If you tell a particular name for Coca-Cola, then people will associate Coca-Cola with a particular beverage brand. Okay, beverage has Coca. Same like that. If you're talking about, for example, Dell, then people associate Dell as a brand name of a particular laptop brand, laptop and computer accessories brand. So this is what called as trademark. Trademark, this includes not just the brand name, it also includes the logo of that product, device, shape of that logo and everything. For example, like taking Dell's example, DELL, it's a bird mark. It's a particular plain bird. It is also protected as a trademark. At the same time, the logo of Dell, which is in under a circle D and E in a slanted way, the way of representation of that brand name itself is also protected as a trademark. So trademark includes names, logos, device, shape of that particular product. Everything can be protected as a trademark. The main purpose of obtaining protection in respect of trademark is to exclude others from using the same or similar marks. Like I said, in patents, if someone is using the same technology for their products, you can enforce it. In trademark, if someone is using a particular logo, the same logo or a logo which is similar to your logo, then also you can protect it. It's not that the opposite party has to use the same logo or same trade name like yours. Even if they're using some brand name or logo which is somehow similar to your trade name or trademark, you can file a case against them to stop them from using that one. This is important because there are so many brands which have their logos in a particular stylized way. Take for example Coca-Cola. Coca-Cola, they have their logo in a separate script. The way of writing the term Coca-Cola is something which is not commonly used by others. So if someone is trying to copy the same and coming up with a different logo, if even if they are using some different trade name, the trade name for Coca-Cola is Coca-Cola, Coca-Cola, but the logo they use is in a separate, in a distinctive representation. If someone is trying to using the same kind of representation for their trademark, for example, if someone is trying to launch a product under the name like Campo Cola or something else, which is not exactly when you are pronouncing that term, it will not be similar to Coca-Cola. But when they are using the same kind of logo for their product, Coca-Cola will be able to enforce their rights against that person. Because what happens is when different branded products are placed in a particular supermarket, Coca-Cola, and very close to that, if they are having another product having the same kind of logo, it will deceive the public. It will deceive the public to think that this product is also similar to Coca-Cola. So what happens is instead of taking Coca-Cola, the product which is very cheaper than that, that will be taken by the public. So to avoid this confusion and deception among the public, trademark registration and trademark protection is very important. Like patents, which is you need to file your patent application first. For patents, the main thing is you need to file your patent application first. But in trademark, registration is not a mandatory requirement. But registration is very important for you to prove your ownership. Even if you don't have a registration for a particular trademark which you have created, or a logo or an artistic work which you have created, you will get protection. But you will have to prove that you are the first one who has created the trademark. You are the first one who have used that trademark in the market. So that you will be able to enforce that particular trademark rights against third person who are using it subsequent to you. But registration is very important because registration will give you a statutory rights. It will give you legal rights in respect of that particular trademark. Once you register your trademark with the trademark office in India, you can use that registered trademark logo symbol. You can represent your trademark as a registered trademark, and at the same time, you will get a legal rights against third parties. The trademark registration will act as a proof of your ownership. Because if you don't have a registration, it will be difficult for you to prove that ownership in that particular mark. You will have to show when you have adopted. You will have to prove before the courts that you are the first one who has created that logo or trademark. You are the first one who has started using that trademark and all. So, not to avoid all these things, you can go for a registration. Once you file a trademark registration and you get the certificate granted in your name, that certificate will act as a proof of ownership of that particular trademark in your name. So, when you have a registration in your hand, at the time of enforcing your rights against third parties, you can use it. It will help you in claiming some additional damage from the opposite party. When you don't have, when you there is a registration before the courts, you can also claim for damages. You can also claim for profits and accounts from the opposite party. But when there is no registration, you can only stop that person from using the trademark, and you can only claim loss of profit only in respect of that opposite party's use. In case if the opposite party is using that conflicting the similar trademark for a relatively small amount of product, and he has not generated any income or revenue out of it, then without registration, you will not be able to claim any damages from the opposite party. You'll be only able to stop them from using your trademark. So, for the purpose of trademark registration, you will have to apply it at the trademark registry. And the trademark registry, same like patent office, they will also examine your application to see if there is any prior registration available. If there is any prior registration which is similar to your registration or it's already registered or not, they will check everything and then they will issue a certificate of registration. This certificate of registration of trademarks is valid for a period of 10 years. In India, it is valid for a period of 10 years. But like patents, it is not limited, because for patents, you cannot extend your patent beyond the 20 years period. Patent is a limited period, right, which is granted by the government. But trademarks, after this 10 years period, you can renew that trademark for subsequent period of 10 years. Irrespective of number of renewals, you can go ahead with renewing for 10, 10, 10. You can keep on renewing your trademark for the next subsequent period of 10 years. Because patent right is something which is given in respect of a particular invention which needs to be disclosed to the public, which needs to be available to the public. That invention, as per the basic principles of patent, is that once the inventor discloses the information to the government, the government will give the rights in respect of that particular patent for a period of 20 years. But trademarks, if someone is restrained from using a trademark after 10 years, then same brand can be used by others as well. So in order to avoid that, what the government gives you is renewal of a trademark for a particular period of 10 years and 10 years subsequently. So once you have trademark registration, you can renew it subsequently for 10 years, irrespective of, unless you exit from the business or you stop using the trademark, you can keep on renewing a trademark for a subsequent periods of 10 years. So apart from this, this trademark is also a territorial rights. Same like patents, these trademark rights can be enforced only in India if you have registered your trademark in India. Same like international patent application, for trademark as well, we have an international system under the Madrid Protocol. It is also under the World Intellectual Property Organization, WIPO. So when you can file your application in India, you can also file the same application internationally at the WIPO level to cover different countries. In case if you have some product under a particular brand name, in case you have prepared some, the product is, it could be anything. It could be a device, it could be a food product, it could be a clothing product, it could be a computer related product, anything it could be. If you have selected a particular brand name, if you have selected a trademark for that name, once you get it registered in India to protect it in India, if you think of expanding your business and product under that particular brand name internationally, you will have to choose the countries where you have to protect the rights. When you are entering that country, trademark registration is very important. Apart from India, if you are protecting your trademark rights in other countries, when you are launching your product in those countries, it will be easy for you to enforce your rights against third parties violating your right in those countries. What happens is, like, there are popular brands like LG, Samsung, which are into different consumer goods like electronic goods, not just refrigerators, TVs, or fridges. they have been involved in different kind of activities, different product range they have. So when they are expanding their products, for example, if they Samsung is into mobile phones and all, now they have decided to expand their products to television ranges, TVs, and home theater systems. When they launch their product in other countries in respect of their product, somebody or other, they are using their product name Samsung or some product name like Mamsung, Damsung, just by changing one or two letters from a particular brand name, and they're using this in other countries in respect of the new products which Samsung is planning to launch. So at that point of time, without a registration in other countries, it is difficult for Samsung to enforce their right against those third parties who are using trademarks like Mamsung, Damsung, just by changing one or two letters in this one. When pronouncing it that term Damsung or Samsung, it will be same like Samsung. In case they are using the same logo as Samsung, the people will assume, the purchasing public will assume that the product is from Samsung or product has some relationship or association with Samsung. But in reality, it's not the case. It's something which is manufactured by some different entity. So in order to enforce Samsung trademark rights against that third party, registration in other countries is very important. Whenever they are planning to launch a product in other countries, they need to get their trademark registered in those countries so that they can get protection of some kind in those countries. So apart from this production mechanism, when you have your trademark registered, this trademark registration will give you the right to use that registered trademark symbol. Without a trademark registration, if someone is using that registered trademark symbol with their brand name, it is actually an offense under the act. The trademark office can file a case against that person from using that particular R logo. You must have seen this registered logo, right? The round logo and then capital R inside it. So this registered trademark logo symbol can be used only by the person who has registered the particular trademark and brand name. If anyone is using that registered trademark symbol without having any registration, it's an offense under the act and it's a punishable offense. There is a fine that the government can impose for up to 2 lakh rupees. So getting a trademark registration, apart from protecting it from some third parties misusing the same, it is very important to keep that armor. The our logo is very much, the registered trademark logo symbol is important because when you are having a product launched in the market and the package have that registered trademark symbol, it means that this is a particular brand name of a particular entity. The people will think that yeah, this is a brand name already registered and this person is using this trademark, this brand name in respect of his product with the registration in hand. So people assume that this is a good brand. The registered trademark symbol sometimes it helped in people recognizing that this is a particular good brand of product, brand of a particular individual or a company. So registration is very much important in this aspect. Though registration is not mandatory under the Act, registration of a trademark is recommended to claim your rights, claim your ownership, and claim damages against third parties misusing the same. Okay. Like I said, for trademarks, the protection term is actually 10 years. It can be extended for subsequent periods of 10 years. So, being MBA students, I'm sure you guys will be joining a company sooner, or you will be starting a company, your own company. So, this trademark registration will help you in your own establishment. In case if you are going to start your new company, you will be naming your company, right? When you are naming your company, you have to get your trademark, the brand name and company name registered as a trademark, so that someone in future, no one will be misusing that same. In case if someone is using the same kind of name or corporate name or logo, anything which you are going to use in your business, you can stop them. You can file a case against them and stop them immediately from using it. What happens is if someone is misusing that trade name, and in case if, for example, you have started a company and you are into some clothing business, okay, and you have a trade name called XX, and if somebody is also using the same XX in respect of his products and he is providing some low quality goods, what happens is when public purchase that product assuming that it's yours, when public purchases the product of the third party, that low quality product assuming that it's your brand, then it actually damages your brand, right? When public uses that product and find that to be faulty or defective, then it actually affects the brand value and identity of your product. That's the reason why you need to enforce your trademark rights against those third parties. When you are finding someone who is using a trademark which is similar to your one, then you will have to immediately enforce it. You have to take the legal steps to stop that person from using the trademark. For that, registration will help you. The registration of a trademark will help you in getting damages from that person, in simply proving that you are the prior owner of the trademark application. Because what happens is when you file a trademark application, same like patents, you are also getting a trademark application and trademark filing date. So this filing date is very much relevant. Once you have a filing date of a trademark application, for example, you are filing your trademark application today, you will get rights from today. In case if someone is misusing your rights in down the line after 6 or 7 months, if someone is using the same trademark like yours, then you will show that trademark registration to show that you are the prior owner of that particular trademark. And you will be able to enforce that trademark registration against the third party who is misusing it. So, since you are MBA graduates, you will become MBA graduates in the next 6 months or 1 year. Trademark registration is very much relevant for you. Doesn't matter whether you are going to join a company or whether you are going to start your own company. But brand name and corporate name of your company, wherever you are going to work or where you are going to start business, it will be very much important that you have to recommend your company to get it registered, properly check the market. The market research is very much relevant in respect of trademarks. When you find some third party's product which is coming under your same trademark or similar trademark, you will have to enforce your company's rights against the third parties so that it will help in developing your brand value and help in stopping the damages that could be caused to your brand name by way of use of the third party's cheap products. So for trademarks, this is it. Trademarks, if you recap, it's just a brand name, it's a logo, it's a shape or device. It could be any representation of a particular product, that representation which is associated to a product and a particular person. And the trademark registration is not mandatory. Of course, registration will be helpful in terms of enforcing your trademark rights against third parties and claiming damages from the third party. And trademark registration is valid for a period of 10 years in India, and it can be renewed for X number of years. You can keep on renewing the trademark for 10 subsequent periods of 10 years. And when we come to the next one, copyrights. Copyright registry, copyright is also same like patents and trademark. It's also right granted by the government to a particular person in respect of his intellectual works. But the type of intellectual work coming under copyright is totally different from patents and trademark. For patents, it's something related to invention and technological invention or invention related to agriculture, which has some products which is beneficial in the market and among the public. Trademark, it's about a brand name which helps in associating a particular goods by the public with a particular person and a particular company. So trademark and patents are at different domains. Copyright is something which grant a particular creator a right to copy that work. Apart from excluding others, trademarks or patents are like exclusive rights. These exclusive rights excluding, stopping others from using that particular trademark or patented invention. Copyright is something which gives the actual creator of that work to copy that work. Only this person can copy that work and publish it in the market. No other can copy that work. This is something which is related to a particular work, which includes copyright generally includes literary work like books, artistic works, if there is any artistic creation like photographs, paintings and all, that can be protected as a copyright. Same like that, copyright is also, it will also cover musical notes, sound recordings, even cinematograph films, even cine films. If there is a film produced by a producer, he can get it copyrighted. You must have heard about this producers and actors fighting into copyright disputes with respect to their films. what happens is if a particular producer has produced a film and he has copyright over that, irrespective of registration, same like trademark, registration of a copyright is not mandatory. Once there is a work created and once the work has been published, the person who has created the work will get copyright. Copyright is for the creators, authors, and actual producer of that work. So, if there is a literary work, if someone is writing a book in respect of some educational syllabus, or in respect of any dramatic work, or in respect of some stories or something, if he's writing something and if he's getting it published, he will get copyright. Irrespective of registration, he will get copyright in respect of that particular literary work that he has created. The literary work, the only thing is that the literary, artistic, musical, sound recording, whatever it is, film production, whatever it is, it has to be original. It should not be a copied version. If the particular work that a particular creator has created is original, then he will get copyright irrespective of registration. At the time of completion of the work, at the time of publication of the work itself, he will get the copyright. Publication in respect of book will mean actual publication. Artistic work, displaying in some museum or something like that. Musical recording, sound recordings, publication of the same through online and offline medium. Photographs, publication through offline and online medium. So the day when that particular work is getting actually published, the person will get copyright in respect of that work. That person only can copy that work. If there is a photograph, only that person can create copies of that work and sell it in the market. If there is a literary work, if there is a book published by an author, that author only can copy that book again. He can copy that book and sell it in the market. Nobody else can sell it. If anyone is selling that goods by copying literary work of a particular person, this person can enforce their rights against a third party. Like I said, registration is not mandated requirement for copyright, but same like trademarks, registration will give the proof of ownership of that work. Because unlike trademarks will be you will be able to use the actual use of the trademark by showing the bill or advertisement or something like that. But with respect to copyright, the right starts from the date when you complete the work, complete the book, or complete the sound recording or musical work or photograph. If you take the photograph, the time you took that photograph is the date from which you can claim protection, claim rights over that particular photograph. But the time and completion of the work, for example, book, if you have written a book, time of completion of the book, it will be very difficult to establish before the courts for the purpose of claiming rights over the same. So, in order to avoid all these things, you can go for a registration. Once you complete the book and the book is ready for publication, you can go for a filing at the copyright office. You can file a copyright application along with a copy of the book. So the copy of the book will be kept at the copyright office in their records with the filing date. So the filing date will show you that you are the owner of that particular book from that date itself. It will help you in showing actual ownership of that work. If you have created it today, then from today itself you can claim rights. But in order to prove that you have created this work today, it will be very difficult before the courts to prove that. In order to avoid that only, you have to go for a registration, and registration will show you the actual proof of ownership. It will show you that you are the owner of that particular work. And at the same time, registration will also help you in showing prior rights as well. Example, if someone is, you must have seen few films, right? I'm not sure, I don't remember the exact name of the film, but it's a film having Prakash Raj and Prithviraj in that movie. Prithviraj is a story writer. He used to prepare a great story, and Prakash Raj simply he took the story from him and showing it to a producer, he became an actor. What happens is Prithviraj hasn't registered that particular story. He only created it, but he has not registered. There is no proof there is no document to show that he was the actual writer. He is the creator of that work. When Prakash Raj copies that work and he's using that one as his own, then he will be able to claim rights. Prithviraj was not able to claim ownership over the one. Same like that, if you are not able to show that you are the actual creator of that work, you will not be able to claim copyrights. That's the reason why this registration system is in place. In India, we have a copyright office in Delhi only, but anyone can file it from anywhere. You can simply send a post, the application along with a copy of your actual work, be it a photograph or be it a writing or a film, music, sound recording or whatever it is. If you can file an application, you can send your copyright application along with a copy of your particular work to copyright office in Delhi. Once you get a filing date for that one, it's actually a proof. It's a record kept at the government office. You can use that record to show that you are the actual first creator, writer of that work. So registration is very much relevant only to prove that you are the first creator, to show the ownership of that particular work with you. So it will help you in enforcing your rights against third parties. If someone is trying to copy that work and if someone is trying to adopt the same kind of same like that. For example, if there is a story written by a particular person and he has published it as a book, if someone is attempting to take a cinema, if someone is attempting to take a movie on the basis of that story, then the story writer can go and claim damages from that person. They can claim rights and ownership in respect of that particular movie as well. So when you have a registration, you will be able to easily enforce it against third parties. When there are, you must have heard so many cine cases like at the time of release of a particular film, there will be so many copyright cases filed by some third parties against the producers and writers. So in most of these cases, what happens is this actual authors, actual creators of the particular story and art, they don't have registration. So at the time of filing the suit, they'll not be able to prove that they are the actual owners. So court will not grant any injunction. The movie will go ahead with their release. The producer will go ahead with the release of the movie. In case if they have a registration for that copyright, they'll be able to show that they are the first owners. This is the same story which is used in the film, and it will be easy for the courts to grant injunction against the producer from releasing that film. So registration of copyright and trademarks, these are not mandatory as per the act to file your lawsuit against third parties who are violating their rights. But registration is recommended which will help you in proving you are the actual owner, you are the actual creator of that particular trademark and copyright. Okay. And, for trademarks, like I said, we have a protection for 10 years and subsequent periods of 10 years. For patents, the protection granted by the government is only for a period of 20 years, not more than that. But for copyrights, it's a work. It's actually a literary or artistic work of a particular person. As per the Copyrights Act in India, a person who is having some copyright in the work, he can use that for a period of until end of his life. He can use it throughout his life until his death. He can use that copyright. He can keep on copying that book and sell it in the market, and also stop others from copying the same work. In India, actual protection granted is life of the author. Until life of the actual creator of the work, he can claim rights. And even after his death, his successors, his heirs, his legal heirs or successors, they can also claim rights in respect of the copyrighted work of the author for a period of 60 years. So the copyright protection is for until end of the life of the person who has created the work. In addition to that, his successors can also claim rights in respect of the work, the copyrighted work, for a period of 60 years. So if a particular book is authored by a person and he has published it himself, so he can copy that book and sell it in the market for the next rest of his life. He can do it, and his successors can also come and use that same thing, and they can also copy the product and sell it in the market for a period of 60 years after death of the original creator. So copyright is actually a wider protection. It's a kind of a big protection granted to the author in order to reward his actual creative skill, in order to reward the work involved, the skill involved in creation of the work. So copyright protection is wider in nature and gives a wider range of protection, and it apart from copying, it can also be enforced against third parties who are misusing that by way of adopting similar work. And copyrights. This is it with copyrights, and the next one is designs. Designs is sometimes confused with patent rights. Okay, what happens is designs rights is actually it's only for the aesthetic element. It's only for the external appearance of a particular product. Like I said, if take for example, if there's a bottle design for Coca-Cola, the Coca-Cola's bottle design is protected as a industrial design as per the act. As per the relevant acts in India, it's Industrial Designs Act 1999. But that design should not have any functionality. It should not have any actual future associated to the product. Patents are actually granted for a particular future and the functionality of the product. But design rights are granted only in respect of the external appearance, not for the functionality. Patent rights, it's a separate rights with respect to actual functionality, technology involved, actual manufacturing process and all. But design rights, it's only for the external appearances, because external appearances of a particular product, it is also considered as a particular type of property which associates that product to be a brand of a particular person. Like I said, for Coca-Cola, when you see the design, bottle design itself, you will recognize that as Coca-Cola's product. Same like that, if you see the Fanta bottle design, it's a different bottle design. Okay, it will be the purchasing public, those who are going to the market and buying the product, they'll be able to understand that this is a product of this is a reputed brand. This is a Fanta brand. It's a reputed brand of Coca-Cola. Same like that, Harpic. Take for example, Harpic. You can see there are so many bottle designs which are very similar to Harpic bottle design in blue color and having a red color cap in a slanted design way. Actually, Harpic, they have created the bottling design to distinguish their product. But there are so many parties. You must have seen so many different brands having the same bottle design with a different brand name. So, in order to stop those persons, what Harping can do is they can register the external appearance of their product, the bottle design under the Designs Act, and get them registered so that they can stop others from copying the same bottle design. Design is somehow different from trademark, because trademark is in respect of the brand name, the logo which Harpic has. The trademark Harpic and the logo and the label design, these are covered under the Trademarks Act. But the external appearance of the product, the bottle design and all, these are covered under the Designs Act only. This is not just limited to a bottle design. Even for mobile phones, laptops, TVs, nowadays there are so many curved LEDs and all coming. So this curved display is also protected as a design rights. The external appearance of the curved design in respect of LED TVs are also protected as design rights. In case if someone is misusing the same kind of curved design, the person who has registered that, the person who has first registered that particular curved design, they can enforce the rights against third parties. I hope you guys must have heard about this dispute between Samsung and Apple in respect of their mobile phone design. It was in 2010, though. It was very in the earlier stage of smartphones. What happened was like Apple had a design rights in respect of their phones, mobile phones, which was first launched as a smartphone. Hey, Samsung, when they introduced their own smartphone, they adopted a similar kind of design, which was more similar to Apple's. So what happened? Apple was able to enforce their right because they had their well-established intellectual property rights mechanism in their company. They had a separate team for IPR, and they already registered the design which was created by Apple. So they were able to successfully enforce their right against Samsung, who was using the same design. It was not actually the same design, but a similar design like Apple. So they were able to establish the design rights against Samsung. They were able to claim damages in millions. Actually, it was more than 100 million USD. 100 million US dollars in 2010-11 was really huge, just for protecting your design. And it's not just like I said, registering your intellectual property and protecting your intellectual property is not just to protecting it against third parties who are misusing the same. It's also in respect of generating revenue in respect of your products, like Apple did. They just filed a lawsuit. They protected their trademark, they protected their design rights. At the same time, they also claim damages of over millions of USD. It will also generate income. It will also generate revenue for the company. So it's very much important that companies, it's not just companies, even if a startup business, they come up with something new in terms of functionality for patents, something in new terms of brand names for trademarks, something new in terms of designs, the external appearance for design. If they find it new, if they adopted it, if they have created that, they will have to think about registering the same so that they will be able to enforce it against third parties and they will be able to generate revenue out of that. Protecting IPR is not just a mechanism that you get it registered and you have something in your name in the government records, right? It's not that you have your patent registered in the patent office and you have your name in the patent office records. It's not just to have your name in the patent office. It's to actually enforce it. It's actually to generate revenue out of that. Generating revenue from patents, not just by of selling it, not just by of licensing it to third parties, not just in terms of generating loyalty out of that particular patented invention, but it is also helpful in terms of getting damages from the third parties who are misusing the same. The third party, it could be a small party or it could be a big company, whosoever it is, who are they are, if they are misusing your trademarks or patents, you will be able to claim damages by way of your registration. So being a MBA students, you will be, like I said, you will be joining a company or you will be starting up your own in the very near future. So you will have to have a clear understanding of the major intellectual properties which are related to your companies. Like I said, these are the four important intellectual property types: patents, trademarks, copyrights, and design. But in addition to that, there are other property types like farmers' protection rights. In case if you are joining a company or going to start a company which is related to agricultural business, which is related to pesticides or like fertilizers and all, which is involved in producing fertilizers, this farmers' protection rights and plant varieties rights will be very much important for you. This is also a type of intellectual property right, but most of the people have no idea about these kind of additional intellectual properties, because when we talk about intellectual property rights, everyone will say that everyone will say that IPR is something related to patents, copyrights, or trademarks, max. There are other types of intellectual property rights which will be relevant in terms of business when it comes to actual business and use of the product. It's going to help the particular company when they're enforcing and protecting it. It's not just in terms of stopping the third parties from using the same. It's also going to help you in generating revenue out of the same. Like I said, if you're joining a agricultural related company like FMC and all, you'll be able to get the plant variety rights. There are so many genetically modified seeds and genetically modified products launched by different FMCs, and these genetically modified products are also registered under different types of intellectual property rights. Apart from patents, these are also registered as a plant variety of a particular company. This plant variety is a separate type of intellectual property rights which can be enforced against third parties. So depending upon the place where you're going to join, where you're going to start your business, you will have to give importance to the intellectual property rights in the same way like you are going to give importance with respect to the business expansion and marketing. Okay, marketing is something which is going to help the business develop. That's the main thing which is going to develop. But at the same time, giving importance to the intellectual properties is also going to help the company in growing further. So, being a MBA students, you will have to. I'm sure this intellectual property rights will help you in developing your business, expanding your business, and getting it to a successful path. So, when someone in your company is developing something new or creating something new, you will have to recommend getting the same registered in the name of the company, in the name of your own business, so that the same will be used against third parties and the same will be helpful in expanding your business in terms of revenue as well. So I'm sure you guys will be understanding more about intellectual properties when you actually start working for a company and when you actually start launching your own product or business. But I hope this session may have given you some basic idea about the different forms of intellectual properties and how it can be helpful in terms of actual business nature, actual launch of the business in the market and all. I, that's it. In case if you have any questions, what we have discussed and about intellectual property in general. now.
Students, do you have any questions?
Sir, I do have a question.
Yeah.
Saira here. Yes, sir. How much does it cost to get a trademark protection, sir?
Trademarks in India, if you are an individual, if you are going to file your trademark application in your own name, the government fee is only 4,500. But in case if you are working for a company and you want to get that trademark registered in the name of a company, the government fee is 9,000 rupees. And the process is like it will take minimum 5 to 6 months to get your trademark registered at the trademark office. And if there is any opposition from some third party, for example, I will just give you a brief information about the trademark prosecution cycle. Once you file a trademark application after paying the government fee, 4,500 or 9,000, whatever it is, what happens is the trademark office, they will examine that application to see if anyone else has filed a application for the same trademark or similar trademark earlier. If there is no similar trademark, the trademark office will publish your application in the trademark journal. There is something called Trademark Journal. Once they publish it in the Trademark Journal, any third party, it will be available for anyone to view it. So any third party who thinks that your trademark is similar to theirs, or who thinks that your trademark should not be registered, they can file an opposition within a period of 4 months. Okay, so if nobody has filed an opposition within that 4 months period, the next month the government will give you a certificate of registration. So from filing to registration, generally it will take 5 to 6 months at the trademark office. And in case any objection from the third party, it will go for years because the opposition proceeding is same like the court proceedings at the trademark office. In the opposition proceeding, they will file an opposition. You will have to give a counter reply, and evidence stage will be there. Hearing will be there. They will appoint a personal hearing as well. So if there is an opposition, the time period will vary. It will go up 2 years, 2 to 3 years. But if there is no opposition, you will get your trademark registered within a period of 6 months. So the government fee is 4,500 depending upon the nature of the person who is applying. If it's a company, it's 9,000 rupees.
Thank you so much, sir.
Any other questions?
Students, anybody have any questions? Dharnish.
Sir, I'm having a question. Sir, how can I protect my intellectual property rights?
It will be great if you can explain the kind of intellectual property right you have or you propose to have. Like I said, there are different types of intellectual property. Okay, so if you can explain me the exact type of property you want to protect, I will be able to give you a detailed information about that.
So, example, YouTube, then Instagram, then the land records.
Okay, for YouTube and all, these are actually YouTube. They have different intellectual properties covered under the same. YouTube name itself is a trademark. Okay, in case if you are going to launch a channel in YouTube and post your videos and generate revenue out of advertisement in that video, the channel name which you are going to use, if you have decided any channel name, you can get it registered as a trademark. But you have to make sure that that channel name is not copied from others or it's not similar to the channel names which are already there in YouTube. If you have some inventive trade name, a coined name for your channel, then you can get it as a trademark. For trademark, like I said, you have to file an application with the trademark office. There are trademark offices located in 5 cities in India: Delhi, Mumbai, Chennai, Kolkata, and Ahmedabad. So you can file a trademark application either yourself or through an agent and get it registered within a period of 6 months. And same like that, in YouTube, when you're publishing a particular video or a recording, sound recording or audio, that video content can be protected as a trademark. If it's a original video content, the same will be protected as a copyright. Okay, copyright exists in the actual video that you have recorded and published in YouTube. Like I said, copyright registration is not mandatory, but the date when you publish the copyright, when you publish that video in YouTube itself, you will get a copyright in that one. If someone is trying to like imitate or provide a content which is very similar to your one, the ideas cannot be protected. For example, if you're launching a YouTube channel for comedy programs or for do-it-yourself kind of videos and all, the ideas cannot be protected. Anyone can publish video with respect to DIY or comedies, musical thing. But if they are copying the exact content from your video, if your video has some specific content with a particular place or location, having some background, having some music created by you, if someone is copying the same and publishing it in their YouTube or Instagram, you can file a case against them to stop them and claim damages. Like I said, if you are registering that particular video which has been created by you as a copyright, if you have registered the same, you can also claim damages against a third party who is violating that rights. So for copyright registration, you have to file your application. The copyright office is in Delhi only, but we can file your application. After completing the application, you can send it by post to them with the copy of the actual work. The actual video you have prepared, you can copy it in a CD and send it to them. There is an online mode of filing, but the online mode doesn't accept any video recordings for more than 5 GB, so it will be difficult to send it. So you can send it by post. For copyright, you can send an application by post. Subsequently, if there is any objection from the copyright office, they will ask you to rectify the same, and they will not refuse it as such. If there is any additional requirements like details about the particular creation, in case if you are creating a video with someone else face, if someone is appearing in your video, you have to get rights from them as well to get the particular video registered in your name. So if there is any objection, copyright office will send you an objection letter. You have to reply to that objection, and then you will get registered. Copyright and trademarks, the registration process is not that complex comparing to patent. Only if you have a patent, an invention, patent application will have to be filed at the registry, and prior art search will happen. The patent registration process generally takes 3 to 5 years because of the different complexities involved. Copyright and trademarks for your YouTube channel and all, it will be easy to get done.
Yeah, okay, thank you, sir.
Students? Students, anybody have any questions? Gauri, Hariharan, Jyotika?
Sir, then for the land records, how can we protect our land records?
Which one?
Sir, land, sir. Our
Land?
own land, agriculture
These are
land.
physical properties. Like I said, physical properties are different from intellectual properties. Intellectual properties are only in respect of the thinking and some work which has been coming out from your mind to your thinking capacity. Physical properties, for that we have a separate registration process. You must have visited the registration office, sub-register office are there in every towns and cities. For land registration, is a separate thing. It's totally different from intellectual property. Land registration, there is a specific procedure for registering your land. These are not to be confused with intellectual properties. Okay, land registration are same like how you register your when you are purchasing a building or when you are getting your lease agreement executed. For registering everything, there is a separate registration authority in almost all cities and towns. If you are in Coimbatore, there are at least 14 registration sub-register offices there in Coimbatore to register your land. That's a separate proceeding.
Yeah, okay, sir. Thank you, sir.
Sir,
Yeah.
so if one person create one product but he didn't get a copyright, then another person copy that product and get copyright for that product, so that creator can claim that, sir. Is it possible?
Yeah, with respect to copyright, like I said, registration is not a mandatory requirement, but you will have to prove that you are the actual creator, you are the original and first creator of the product. Copyright registration will help you in proving that you are the first creator because you will get the filing date. But apart from that, if, like I said, if you are writing a book or if you are creating a musical content at your home and you are yet to publish it in YouTube, okay, if you are publishing it in YouTube, you will get the date of publication and everything. From that date, you can claim rights. But if you have created and if you have finalized your particular work, like musical recording or book, whatever it is, and if you have not saved it, if you are not able to prove that you are the actual creator, it will be difficult for you to enforce your rights against the second person who has actually registered it. If you will be able to prove that you are the actual one who has created. For example, if you have saved it in your folder or if you have sent it by mail to someone else, that email copy can be produced before the courts to prove that you are the actual owner. In that case, even if the second person has registered that work as a copyright, his copyright registration can be cancelled by the courts and you will be able to enforce your rights. But the only thing is that you will have to prove that you are the actual owner, you are the original creator. You will have to prove the date of actual production by you is prior to the date of actual registration by the second party. So if you will be able to do that, you will be able to enforce it. No need to worry about registration, but the registration will give you some additional kind of protection. That's it.
Okay, sir. Thank you, sir.
Students, I think all the questions are over. Thank you, sir. Thank you so much.
Thank you.
Saida? Saida?
Yes, ma'am. Thank you for your excellent and inspiring speech, sir. I now invite Venkat Balaji of second year MBA to propose the vote of thanks. Over to Venkat Balaji.
Yeah, good afternoon, everyone. I would like to thank each and every individual who provided me the privilege of presenting the vote of thanks for this event. I would like to thank our guest, Advocate Balaji sir, for attending and enlightening us with his knowledge. It gave us a deep insight into the topic and also revealed some interesting facts. I'm pretty sure even the explained topic is not into the curriculum. We have spent the most valuable time to understand the life lessons and deep knowledge. Thank you for your hard earned, valuable time and insights, sir. Then I would like to thank our respected principal, sir, Dr. B.L. Shivakumar, sir, for the influencing support to conduct the webinar. I would also like to thank the head of the department, Dr. J. Bomini, ma'am, coordinators, staffs, and students for their continuous effort and kind gesture to arrange this event. Then I sincerely thank everyone for granting me this opportunity to express my thankfulness. With these warm words, we move to the end of the today's session. Thank you.
Thank you. Thank you,
Thank you
guys.
so much, sir. Thank you. Students, regarding next class, we'll inform you in our official. Thank you for joining today.
Yeah, thank you, madam.